reasonable prices here. You can't afford them outside, but you can certainly afford them here. There's a big difference in the way medicines being delivered. So,
I know one person has a agent that specializes in bringing people from Addis to Thailand for
yes,
medical treatment.
we did. My husband and I. Yes. I mean, it was most efficient, I have to tell you. It was very impressive. How they handle, I mean, literally handle everything. Very
isn't it?
The human rights abuses committed by the regime, how they were investigated and prosecuted, and what lessons are learned in terms of memorializing human rights violations and making sure that they will never happen again. Let me start by introducing myself. My name is Mulacho Daini. You'll see from the session program that I'm quoted as lecturer at Addis University College of Law. Well, I used to be a lecturer at Addis University. Currently, I'm practicing law. I'm an attorney and consultant. I think I left Addis University about 3 years ago, but I'm still interested in working with the faculty. So, without much ado, I would like to introduce the presenters or the panelists for this session. The first presenter is Mr. Yusuf Kiros, who is currently a judge at the Federal High Court of Ethiopia, the criminal bench. Prior to his appointment as a judge, he has worked for a long time, I think for almost a decade, at the Special Prosecutor's Office. It is really from the time when the Special Prosecutor's Office commenced its work in terms of investigating and then prosecuting those who are responsible for human rights violations during the military regime. So he will in essence tell us about the political and historical significance of the prosecution and also how the Special Prosecutor's Office was established, what its mandate was, what it has accomplished in the past decade or so. I think the Special Prosecutor's Office has currently accomplished most of its tasks, and therefore it's on the way of being closed. But initially when the Special Prosecutor's Office was established, they were facing with this daunting task of investigating human rights violations in Ethiopia for 70 years, and they had to do their investigation in all parts of the country, interview people, including those who were taken into custody, witnesses, and the like. Personally, I was working with Intrafrica Group since 1996, and I was monitoring the trials of former Ethiopian government officials, so I know how difficult their task had been. Thousands of people were prosecuted. There were very few prosecutors in their office, and I remember how challenging the task had been for the office. And I really congratulate the Special Prosecutor's Office for carrying out such a big mission with all the challenges that they faced. So after Mr. Yusuf's presentation, we'll have Dr. Solomon Gitana, who will be presenting on the untold story of Red Terror victims. Beyond what has happened to the victims of the Red Terror in terms of arbitrary detention, in terms of killing, their respective families have to carry this huge, burden. I think many of us here have lost our loved ones, one way or the other, on one side or the other, and would understand what it really means to have your sister or brother taken to jail, tortured, and disappeared without even having any explanation about that person's whereabouts. So Dr. Solomon is currently professor at Central Michigan University. He specializes in history and more specifically on Ethiopian immigrants, the role of Ethiopian immigrants in American history. His current research is the Red Terror in Gondar. As you know, Gondar is one of the provinces where organizations like the PRP were hit at the hardest, and their members were subjected to killings and torture by infamous Derg officials then. After Dr. Solomon's presentation, we'll have Ato Makon Walde. He is currently the head of the Red Terror Martyrs Memorial Museum. Ato Makon has worked as in different administrative positions at the Federal Supreme Court and the National Election Board of Ethiopia. But more importantly, he has been a prisoner during the imperial regime. He has been jailed for 8 years. So he would speak on basically the process of establishing the Red Terror Martyrs Memorial Museum, what its contributions are in terms of memorializing the atrocities and lessons for the future, and how it can also contribute to the AUHRA. So I would now invite Mr. Yusuf Kiros to commence his presentation.
Okay, thank you, Mr. Kume, and first of all, I would thank the organizers of these meetings, because this is very important for today and tomorrow, because this type of atrocities has to be stopped once and for the last time. My presentation is as for part, which is the emergency of the Derg and other authorities. So it's better to move from start the political process of establishing the base law. So in some locality, the suspect also disclosed and confessed about the crime committed and showed the location of the mass graves. After the disclosure program, some suspects were arrested and number of arrests increased all over the country. Then after this, we need the transitional justice. As you all know, there are some types of transitional justice. For instance, reconciliation, amnesty, compensation for victims, and others are some types of transitional justice. And recalled separately, only positive votes appealed and varied. 59 people who were the civil and military official and family members of the Emperor Haile Selassie were voted to be summarily executed. The Derg members represent different army units were delegated to oversee the killing. The prison, defense, public security and executive committee of the Derg were ordered to coordinate the killing. Everyone remained at the meeting hall waiting for the execution report. The killing was carried on the central prison or Karchele in Addis Ababa on November 21st, 1974. The assembly received a confirmation report on the same night. The Derg released a press statement the following morning. This was the message under quotation: "The action taken by today against these people shall not be considered
by the Derg regime." I would like to highlight just a few points that I think are part of the conclusion of Mr. Yusuf's presentation regarding the achievements and challenges of the Special Prosecutor's Office and its contribution in terms of memorialisation and transitional justice. As I mentioned earlier, I was working in Drafter Group as an observer of the trials of many of these Red Terror perpetrators and senior government officials of the military regime. And I was able to notice many of the limitations raised by Mr. Yusuf, and there were some issues and challenges, especially in terms of the value of the trials themselves. Both the historical and political value of the trials. The fact that the trials have taken so much time, in my opinion, has diminished a bit their political significance and their historical significance. And sometimes I really wonder whether the reason for the delay of the trials, many of the trials, is the fact that the Special Prosecutor's Office and the prosecution in general have these dual objectives of, on the one hand, ensuring the prosecution and punishment of the perpetrators of those crimes, and at the same time establishing an accurate historical record of the violations. Are really courts the proper venues for setting a historical record of those violations? A case in point, for example, in the case in which Mr. Yusuf himself was involved, Special Prosecutor's Office versus Mengistu Haile Mariam and others, meaning the senior government officials of the Derg. In that case, as Mr. Yusuf highlighted, about 1,275 witnesses were presented. And most of these witnesses were families of the victims, who simply testified that their brother or sister or son was taken one day for investigation. They were visiting him at that detention center and supplying food and the like. And then one day they are told that that person is no longer there. That's simply, in essence, the testimony of probably more than 85% of the witnesses. In terms of adding value, from legal perspective, in terms of for conviction purposes, such testimonies would not really be of that much importance. But in terms of having the historical record set there, they are quite important. So sometimes I wonder whether this issue of having this historical record could have been accomplished by the investigation process, independent of the judicial proceeding. And finally also, what Mr. Esed explained about this problem, that the book published by the Special Prosecutor's Office is of very limited circulation. You know, it's a very important document, but you will not be, most scholars will not be able to access it. And I think the Special Prosecutor's Office should really do a lot in terms of ensuring the dissemination of this thing, and also allowing access to researchers and scholars, you know, to the records of the trials. In some cases, I remember that some of the documents and the evidence, especially the videos of the proceedings of the Derg itself, were not accessible even to some of the prosecutors. They were kept in high confidence, and I think, you know, the issue of access to information and transparency still needs to be addressed. Having said that, I'll proceed to the second presenter, Dr.
First, I'd like to thank First, I would like to thank the organizers, especially Marcus, for Googling me and bringing me here. Second, I would like to express that my presence here is an honor and a privilege, because sitting in front of my former professors and also people who had suffered, and in trying to understand their suffering and trying to speak is a bit audacious sometimes, but I'll try to do my best. And of course, my professors, if I messed up, it's my fault. But it's good, this is people simply because they're guilty by association. And that is what I'm trying to do. I don't think I may have all the time to present the three cases, but I'll look at the family of Member Malapu. Member Malapu was born in what is now Kabale Arat in Gondar, which used to be known as Cherkos Atbel. Many of the Gondar areas, the 44 churches were the ones where localities were named after. Today it's Kabale Arat, but in those days it was Cherkos. He attended Tzadiko Yohannes school, and then he went to finish his high school at the only high school in the province, the Haile Selassie First Senior Comprehensive Secondary School. From then on, he went to join the teachers, the Kotebe Teachers College, and after completing this, he was assigned to teach in Gondar High School. By the time he was assigned, that was the middle of the 1960s, all dates are Ethiopian, the middle of the 1960s, and he, from what I have gathered, seems to have been already recruited by the radical elements that were already forming themselves at the level.
Thank you to organizers and participants. And then shortly present the aim and objectives of the Red Terror Memorial Museum. In 1974, after overthrowing the royal government of Emperor Haile Selassie, the military government came to power. During the last days of the emperor, that is in 1974, there was no organized political party to take over the power. The only organized force at that time was the military, and they elected among themselves 108 members, and they called that group Derg. Derg means a committee, and they took the power out of the hands of the emperor. The military government at first got support from the people. People thought that the new government would bring good things to the public, and they started to support the military government. But the military government did not last long to show its true character. After 3 months in power, they killed 60 higher officials of the emperor without giving them a trial. Starting from that time onwards, killings in every part of the country become higher and higher. According to Amnesty International report, more than 1 million people were killed during that time. In Addis Ababa only, 54,000 innocent young people were killed on the streets of Addis Ababa without getting a trial. Those killings were made under the motto of Red Terror. in 1975, Mengistu came to Mescal Square, carrying 3 blood-filled light bottles, and by breaking the bottles, he said to the public, "We will break our enemies like this, and we will splash their blood on the streets like this." Starting from that time onwards, every revolutionary guard and every military got permission to kill without any reason. Besides this speech, there was a proclamation on the TV and on the radio which exactly said, anybody who thinks so antagonize the revolution should be punished. It was a funny and meaningless proclamation. How can you know about what another person is thinking? It was simply a proclamation to kill innocent people on the streets without giving them a trial. The saddest thing that the dirt did as that if a mother wanted to take her dead son's body out of the street and she wanted to bury her dead son, she had to pay for the bullet that her son was killed. Killing is one thing, asking money for a bullet. We can imagine how evil the military junta was. In 1991, after 17 years of struggle, the military government came out of power. Unfortunately, the leader of the military government, Mengistu fled to Zimbabwe and got protection from Mugabe, and he is still living there. But the rest of the officials of the earth were caught and presented to justice, and most of them got their sentence. After the military government came out of power, and after peace restored, people started to think about the evil doings of the dark. Some interested groups gathered and said to each other, why not we keep memory of the victims of that time? And why not we build a monument of the Red Terror? The Red Terror victims. That was the core idea to establish the Red Terror Martyrs Memorial Museum. The reason why the RTMMM was constructed was to memorize the innocent victims of that time, and also to teach the younger generation that this had happened and this should never happen again in the future. That's why we wrote in the start of the gate of the museum saying that never ever again. Besides this, there are victims and families of victims of that time which are still suffering nowadays. Many victims and families of victims need support. The Red Terror Museum wants to support those who need support. The aims of the construction of the RTMMM. 1. To memorize the victims of the Red Terror. 2. To make a collection of documents, photographs, films, etc. which were about that time. And 3. To support people who are working on the history of that time and wanted to publish different books, leaflets, films, etc. 4. To teach the public that this had happened and this should never happen again by saying never ever again. Number 5. To teach the public that disputes should be solved only by discussion, not by bullet. 6. The museum plans to build similar museums in different parts of the country. And 7. To preserve mass graves in different parts of the country. And 8. To make contacts with domestic and foreign similar institutions in different parts of the world, especially in institutions which are working on civil rights and justice, like UHRA, to make the world a better living place for mankind. Thank you.
Thank you, Mr. Mokonin, for the very precise presentation. I'd just like to invite you to highlight on what has been done in terms of accomplishing these objectives and what has been done so far, just briefly, because the audience is aware of the objectives, but then what has been done.
Okay. By the end of the museums, still we will try to, after the construction of the museum, we will try to memorize the victims of hate terrors, the martyrs' photographs, documents, and that time's newspapers, and so on. We try to coordinate that. And from domestic and foreign members. We try to get formal documents and try to support pupils, not with money, but we try to just to get job in that museum. Just guards, cleaners, and others by their field. We'll try to help them by this condition because, well, RTMM is not a budgeted organization. We get only rent of cafeterias, bookstores, and the others. No other wages. The contribution is, our members are very poor. So, 1 beer in 1 month. The members' contribution is 1 beer in 1 month. 12 beer in a year from the contribution. So, we'll try to get rent money sent projects. We'll try to get money sent to help that victim's family. And we'll try to teach the public in just to prepare the conferences with different topics about that time and to teach the younger people to the next time never ever again. We don't want to see that condition in Ethiopia again. So we'll try to that. And we contact in different parts of the country. For example, in Gondar. You heard about Dr. Solomon Day. The Gondar victims are really very, very, very bad. And we'll try to contact them. We structured the Walkite, Gondar, Gojam, and this is different parts of the country. And to preserve mass graves in the different countries. We have a few mass graves in Addis Ababa, and Mr. Joseph, a few mass graves are there. But in the country there are many mass graves. So we will try to preserve that mass graves and to make contacts with domestic and foreign seminary institutions, just South Africa, Rwanda, and other countries. And this second meeting of AUHRM, we will try to develop this communication and to continue by condition.
Thank you very much, Mr. O'Connor. Now I'll open the floor for discussion. We're supposed to break for tea at this time, but I've been asked by the organizers, in the interest of time and having more time given for discussion, to proceed to the next topic. I'll hereby call upon the discussant, Dr. Edward Kisi. Dr. Edward Kisi is an associate professor of history and comparative genocide at the University of South Florida. He's currently chair of the Global Advisory Board of the Ethiopian Red Terror Documentation and Research Center. The center actually participates in the discussions relating to the African Union Human Rights Memorial. Dr. Edward.
We have a proverb among the accounts that he who mixes a delicious potion cannot help but lick his fingers from time to time. And so in a sense my work is done for me, since the moderator served as both moderator and discussant at the same time. I have been in that process before, because if you are mixing a delicious potion, you cannot help but lick your and therefore what I will do is just reiterate a few common themes and then open up for discussion. I think the message that I brought with me from the United States has already been articulated by many of the speakers who have spoken before me. Documentation, documentation, documentation. The memorialization process can survive without a substantial corpus of documentation. Diaries, videotaped and audio taped testimonies from families, and then of course the SPO documents. So I am here to represent the director of the Ethiopian Red Terror Documentation and Research Center, Hirut Abebejiri, about whom I heard about 6 or 7 years ago when the former Canadian Minister of Justice, Honorable Evan Cutler, called me in my office and then asked if I could assist a young Ethiopian lady who is a victim of the Red Terror, who is trying to do something for humankind and all of us, and that she is looking for some help and direction about how to build a research center very similar to the Documentation Center of Cambodia. Of course, as an Ethiopianist myself, and also somebody who has been very instrumental in building similar archives, I thought that if I were going to perish as a professor someday, then I might as well perish in the service of the African continent, rather than become an obscure professor somewhere who just wrote beautiful articles read by only a few or none at all. And so I thought this service in the cause of humanity was something that I could work with. So I have become part of the Global Advisory Board and Hirut that I have been thinking of recommending for a Nobel Peace Prize because of her indefatigable efforts in actually building the ERT-DRC. Has asked me to stress the documentation. Since my work has already been done for me in that regard by people who have spoken about the necessity for having a core of documents at our disposal that will serve as an antidote to future denial 77 years from now. I think I don't have to belabor that point. I think if you look at what the shared with us, there are some very important issues that I want to re-emphasize, particularly the special prosecutor answered a question that was raised today. Is it genocide or is it not? If we want to get bogged down to conceptual niceties, I think we will be here talking about this till thy kingdom come. I think the SPO answered the question in its decision to prosecute. And that is where international and local laws, or where international and national laws clash in modern jurisprudence, national laws take precedence. And so the SPO was very prudent in taking the position that even though Ethiopia is a signatory to the Convention on the Prevention and Punishment of the Crime of Genocide of December 1948, within its own laws, the Ethiopian Penal Code of 1957, I think Article 234, correct me if I'm wrong, genocide is defined in Ethiopian law as acts committed with intent to destroy in whole or in part not only ethnic groups but also political groups as such. So in Ethiopian law, politicide is genocide, or political mass murder is genocide. And so the SPO made its calculation in modern jurisprudence that where international laws and national laws clash, national laws take precedence. Now here is the catch, and something that the SPO might want to think about. What then happens to Ethiopia's commitment under international law? Given the fact that Ethiopia was the first country in the world to sign the Genocide Convention. If Ethiopia had not signed it, no country would have signed it. And it was Ethiopia's signature in May 1949 that paved the way for the ratification of the United Nations Genocide Convention. So as a pioneer in the ratification process, in choosing to adjudicate this case in the context of national jurisprudence, how does Ethiopia reconcile its commitment under international law? And perhaps equally important, but perhaps far more significant, as 70 years from now, if an aggrieved party decides to file a case for judicial review, what room might be there for the SPO to answer this important question? The second issue that the special prosecutor raised is that in considering whether to pursue a retributive justice, the Nuremberg type, that is to prosecute and punish, or to do the South African type, truth and reconciliation, where people come to confess their sins, are forgiven, and then we all live together ever after. In deciding to choose the path of retributive justice and not restorative justice, what were the arguments, given the fact that you didn't share that with us, what were the arguments that the SPO advanced in order to jettison the truth and reconciliation option for a judicial process? After listening to the special prosecutor, my sense was that the quest for justice was inspired by victims' families, and rightly so. Could it be a victim's justice? What might the SPO respond to that in a future judicial review, should that be possible? And then also, if a retributive justice was pursued, my sense was that the motivation must have been to build a monument of evidence that will serve as an antidote to future denial. Because here, the evidence have been amassed as a preponderance of evidence to demonstrate quite clearly that there was intent to commit murder or to create terror with the intent to induce political compliance. But what is also very important is that here we are not talking about the Nuremberg process, where the Jewish people were going to be given a state of Israel far away from Germany to live, and therefore a retributive justice was necessary. But look at the Cambodian case, for instance, where both victims and perpetrators are going to live in the same country for a very long time. What options did the SPO consider about the key point that Professor Gabriel raised today, reconciliation? And the final point, in terms of my understanding and reflection on the presentation made by the special prosecutor, is that the special prosecutor was particularly interested in evidence, the minutes of their meetings, at which particular decisions were taken, including the decision to execute 59 or 60 officials of the former government, the imperial government. And then also a hierarchical structure, command structure, in which the Derg sought particular evidence and documentation as attestation to the execution of orders from above. If that is the case, and the sense I had was that it reminds me of some of the things that were said during the Nuremberg trial. I was acting under orders. So if the little people in the local areas, the way you present it, which is a rigidly structured hierarchy of persecution, where it appears that the local people were just mindless automatons who were just simply executing orders from above. Now, in any judicial redress or request for judicial review, what are the specific provisions the SPO has for the little people who might appeal 77 years that they were acting under orders from above? I think Solomon's presentation is very much the flavor that we've been looking for. And in a sense, it reminds me of the film A Few Good Men. I think another film should be made in Ethiopia called A Few Good Teachers and Students. And these few good teachers and students first protested against the dead. And the sense I had from the presentation was that indeed these were the first bastions of resistance. The key question is, why did the resistance break down? Because it's pretty obvious that resistance was met with a preponderance of state repression. And so if there were these initial acts of bravery from teachers and students in actually contesting the power of the dead, why could many such demonstrations not have been induced and encouraged? And I think you are very much a student of your mentor, who is a doyen of the study of protest, Gehutareke. So Solomon's presentation is actually a study in subaltern protest. Protest by the small people. And that is particularly important. One very sobering lesson is that suicide under circumstances of terror is a very brave act of resistance. And so the story, forgive me, of the mother who preferred suicide, if I could get some water, to purge a throat that is becoming the vulnerable groups. I think the measure of our humanity is how we treat some of the most vulnerable among us. A mother mourning the plight of her son felt so badly done for by a state that is pledged to defend her rights, and so commits suicide, preferring the dignity of death to the indignity of persecution. Now we have, as Shifarao urged us as we study local histories, to try and come up with some of these stories. And I think the presentation ended very well where the Red Terror Memorial, the Matter Center, is documenting these kinds of stories. And we need more of that. That is where you have a permissive atmosphere of lawlessness, and where the state has reneged on its responsibility to protect the citizenry, and where people choose the painful path of suicide to actually encountering and living with the indignities of demonization. Now, how can we memorialize some of these painful stories so that an African Union Human Rights Memorial become a civic space where we can have a civil discussion about our common humanity? So these are the strands that I saw, and forgive me if I have forgotten some. And I think we will open up the floor for discussions. Keep it very short, don't try to imitate me. When I'm mixing potions that have an aroma, I can't help but fingers for too long. After all, bichawini yabella, bichawini mota. So, questions?
Thank you, Professor. I thought initially you were bringing me of being a discussant and a center moderator. I think now you are taking turn and becoming a moderator as well. Okay. Before opening the floor for further discussion, I would like to invite the presenters or the panelists to react to what the professor has said. Thank you.
Thank you, and thank you, Professor, for raising some interesting questions. I want to address some 2 or 3 questions. First of all, the first questions, the clash between the Ethiopian law and international genocide conventions. In my opinion, there is no clash, because the genocide conventions protect some groups, which was especially during that time important. There is a history. There is a debate between where 2 powers to include whether the political groups included in the genocide convention or not. Especially those who are the socialist camps raise the issue of not incorporating the political groups in the genocide conventions. So there was a big debate. Then the panel, I think, decided that political groups cannot be incorporated in the international conventions of genocide, but it isn't forbidden national laws to protect or to for the political groups. Thanks for the regime of Haile Selassie, which was at that time reactionary, but I think they put such type of advanced law. They broaden the protection of these groups. They broaden the protection for the genocide convention. So they add one group, that is political groups. For instance, during the 1970s, during Cold War, there was socialism and the so-called imperialism. Here in Africa, there are military governments. Most of the oppositions was the political oppositions during 70s. Not racial, not religious, not others. But the most one was the political groups who were killed or tortured by the governments. So the 1977 Ethiopian Penal Code broadened the protection for humanity. I think all the others has to follow such type of protection. So I think there is no clash, but I think it is more of broaden the protection. Then the next question to address was the reconciliation. In our case, the government or the transitional government of Ethiopia choose prosecution is the best solution for the past violence, for the past gross human rights violations. So this is the policy makers who decide to take this kind of solution for the past regime, not the ACPO. The ACPO established after the government decides such type of political decision, which says prosecute all the one who contribute for that atrocities. So ACPOs as an organ of government has to follow that directions, and it puts in its proclamation that it gives 2 mandates. The one was to prosecute, investigate, and to prosecute that atrocities, and the second, which was not well done, the keeping of records. Because as I told you in my presentation, we are not historians. That all of us were the youngest one for 20 years. Imagine how my age was, and we are all lawyers, not historians. We focused on investigation and prosecution of that atrocities, not recording history. Number 2, recording history needs historians, number 1, and it is better to write a history or to register history after the decision of the court. We used that figure of documents from 1 million of documents. We select from that 60 or 50,000 documents from 1 million of documents. We reach everywhere in the country to find such type of documents. Now the trial is finished, the office is phased out, and the next step, as I mentioned in my paper, there are historians, there are politicians, there are young scholars to do that research, to make that research. So, I think we done our job, especially the one who is related in our profession as a prosecutor. Sorry, I'm proud to be a prosecutor of that team. I never happy after now, because I done in my youngest age, but a very, very huge responsibility and historic work. I think you will be see the document in the near future. What type of document are there? What type of testimony is there? So it was I'm sorry. When I heard Dr. Salomon's presentation, that is it was very simple one. I heard a lot of such type of witnesses in the case. There were a lot of mothers who was crying in the trial. There are a lot of friends who are tortured and who lose their friends. Kome was raised the question of witnesses, a lot of witnesses in the court. We have to present that witness, all witnesses, because number one, they have the right to tell their history in front of the court and in front of the defense. Number two, there is a document which decided by a government official simply with and kills them. A minute. Can it take a minute to say such type of writing? Within a minute, they decide somebody's life. It is a document. We have to prove this document, the one who's written or who give execution decision, whether he's dead or not. The condition of the prisoner. We have to give the court, we have to show the court what type of situation was there in the prison, in the family. So we used witnesses. As I told you, we present 1,500 witnesses for only one case, for Colonel Mengistu and others. But we stopped after hearing 710 and something, because it takes a long time. That's why we use such type of witnesses and others. I think the professor read the Supreme Order, the issue of Supreme Orders. In our law, for instance, Supreme Order is only defense when it is the order is legal. Supreme Order has to be as a defense if the order is only legal and legal. For instance, no killing was permitted in any laws during that time. But the Supreme Order, the subordinate killed. So this defense, thanks again for the 1957 Ethiopian Penal Code, defense of superior order can be only raised when the issue of legal order. If the order is not legal, the subordinate cannot be raised such type of defense. For your surprise, Only in one case, the superior order issue raised as a defense. And they can't prove the order. Their superiors also denied the subordinate. We didn't order you to quit such type of things. They denied. Because it is the last time, not the day of death. When they called their superiors to witness them, two of the superior, the Ministry of Superior and the head of the investigation, denied the subordinate that we didn't order you to keep such gun. We didn't order you to torture the prisoners. So, in our case, as I told you, there is no such superior order as a defense, except in one case. Even they raised the issue of superior order. The law clearly answers such type of questions. So I think this is enough for me, and thank you.
Thank you, Joseph. Just switching to my role as a discussant, which I have appointed myself, I would like to add a couple of points to what Joseph has raised. The first one is regarding the defense of superior order. The criminal code basically says that a person, an accused cannot raise a defense of superior order when the order is manifestly illegal. And in this case, it was clear that the order was manifestly illegal. As Joseph told you, for instance, the proclamation established the operational command whatever committee. At best, gave them the mandate to take into custody counter-revolutionaries, not to kill them. So there was no legal authorization for killing, that's one. And secondly, most of the subordinates, the low-level cadres, operated sort of autonomously and took decisions to kill people by themselves. And when it comes to torture as well, you know, most tortures were conducted not on the order of the seniors. There were some notorious investigators, quote unquote, or torturers who were really very much fond of their work, would actually go to the torture chamber even on holidays, on the New Year, on Christmas, and things like that. People like Tafarol Kayed Bukau, if you remember, and many others. There are instances, for example, where the head of the Derg investigation unit, his name is, I think, Major Brown Kapeda, he was later on killed by the Derg itself. He tried to teach his fellow investigators how to torture people. And, you know, in his opinion, his subordinate was not torturing that guy enough. So he says, this is how we do it. And he started strangling the victim, and the victim died on the spot instantly. So, I mean, people really killed with impunity. Nobody asked them. So they didn't need to take orders. And in terms of documentation, I think the military regime itself has done a lot in terms of documenting the human rights records, the human rights abuses. You know, I mean, there's plenty of evidence, as Joseph has said. The minutes of the AZACO, the Revolutionary Operation Coordinating Committee. There are even reports by the different Kabani officials, Revolutionary Guards, AZACO officials, and things of that sort, submitted to their superiors. In fact, when many of them applied for membership in the Workers' Party of Ethiopia, they actually tried to point out what they have done in terms of eliminating the counter-revolutionaries. So in a way, they have admitted their crimes, and therefore, I think what remains now is making these records and evidence open to researchers and scholars for further analysis. And in that regard, I think it's still the ball is in the court of the Special Prosecutor's Office. On the issue of inconsistency between the Genocide Convention and the Criminal Code, I think Joseph has pointed out most of the issues, but this matter has been very much controversial during the trials. I remember that many of the accused were arguing that the Ethiopian Criminal Code, Article 281 of the Criminal Code, if I remember, which included political groups within the definition of genocide, is inconsistent with the Genocide Convention and should therefore be declared null and void. Because, you know, at the time when the criminal code, the old penal code was enacted, treaties had a superior status in Ethiopia, in the hierarchy of Ethiopia. But what the special prosecutor and eventually the court argued was that there is no conflict between the two. In fact, by adding political groups within the list of groups to be protected and, you know, from genocide, the Ethiopian legislator is giving a wider protection. But, you know, we all know this, the controversy surrounding protection of political groups when the Genocide Convention was adopted, especially the objection raised by the Eastern Bloc led by the Soviet Union, stating that criminalizing extermination of political groups would in fact go against the right of a state to defend itself against you know, insurgencies and things of that sort. So that's just what I wanted to reflect upon. I'd like now to pass the opportunity to Dr. Salomon.
I would like to. And you can't hear me.
No. Use the microphone.
I'd like to address Dr. Casey's question. Why wasn't the challenge, I mean, that kind of challenge to the regime didn't continue? The dedication to rise against oppression did not continue. There are many reasons. First of all, what had happened was the generation that rose against the regime had perished, literally and figuratively. Most of them were imprisoned, killed, and the remaining left the country as refugees and asylum seekers. And that was one of the push factors for what we see today, for what we see in reality today, the dispersal of Ethiopians throughout the world. Siddet was a shame in Ethiopian culture. We don't even have the verb that explains refugee and immigrant in our vocabulary, in Amharic vocabulary. For both we use ስደተኛ. It shows that it was not in our culture, but that's how, one. The second thing is the generation that rose to the challenge keep each other. One labeled the other as counter-revolutionary, and they mutually eliminated each other and gave the venue for the military junta to rule with an iron fist. The third reason is opportunism was encouraged by the junta and even rewarded. And this has become, up to now, as a way of subduing resistance against the regime. So opportunism became the rule of the game. 3, the people started to adhere to the traditional adage, zim, አይነቅ ዝም, ፖለቲካና electric. Why? Because the generation after the revolution was not taught to appreciate the sacrifices of the former generation. As it happens always in Ethiopian history, there is no bridge. A bridge was not laid that would continue the struggle against oppressive regimes. Then, the Ethiopian people seem to have been spoiled. It's always students, university students, and high school students who would be screaming for freedom, equality, and the people are bystanders. Even today, they expect these same students to pay the same sacrifice and liberate them, instead of raising the mantra and either joining them or leading the protest against oppressive regimes. When this failed, Ethiopian population today expect the vocal diaspora to free them, to liberate them from imperialism. This is what I am seeing, this is what I'm observing. We have a politically desensitized generation. A generation that wears his pants butt naked. It's unbelievable. A generation that tries to emulate a culture that has no clue, rather than what had been left to it. Then the state has become extremely, extremely powerful because of internal and external factors. First, what the Derg did was, the first time when it came to power, it disarmed Ethiopians. Now, instruments of violence became the Derg became the sole custodian of instruments of violence, the gun. Before the revolution, especially central and northern Ethiopia, everybody was armed. If you saw a student protest happen, parents will come to the scene, some of them with concealed weapons, some of them with sticks, some of them even with rifles. I have seen it in Gordon. They will come. What happened? They could have marched, at least stop the state, or make the state think twice before it takes mass killings. But the Derg took away the the arms of these individuals. So, as the saying goes, "Setoch honen." Without arms, nobody can challenge regime. Today is a global age. Today is the age of, what shall I say, IT, etc. So, when the Derg came to power, it created government associations. These institutions were supposed to work for the people who had been elected by them. But this became extra hands of the regime, instruments of oppression. So the Derg, for the first time in Ethiopia's history, has access to local videos. Now EPRDF had much more access. They have the cell phone. The moment you go to the rural areas, oh, they know you. So the government had become very powerful and very skillful. That's why we don't see those things. Thank you.
Thank you.
I'd love to react to Solomon's commentaries.
The microphone.
Many good insights, but some woeful generalizations. You and I are historians, students of history, and one of the pitfalls that we should try by all means to avoid is making sweeping generalizations. There are several such generalizations you have made, and I don't have time to comment on them, but would love to pursue them with you, maybe at dinner. I have a couple of questions. The first one is to Ato Komalacho. Regarding the evidence that were provided by members of victims' families, you seem to dismiss, first let me say, on the basis of what you said, more than 80% of those, correct me if I'm wrong, seem to say cannot be treated as incriminatory. Am I correct? If my assumption is right, why not? That's one.
Let me just explain, because...
No, let me finish. The other one is directed to Yosef. Thank you so much for your very informative presentation. Now I have a question for you. It's based on my unhappy experience with regard to documents. Professor Kisi emphasized the necessity of documentation. Absolutely essential for the reconstruction of the history of the Red Terror. Now, here at Ababa, apparently, and I agree with you, have never seen such a devoted, dynamic, dedicated, selfless person as this woman. Her entire life seems to revolve around this issue, along with men like Atom O'Connor, who themselves were also victims. And I applaud it. She told me she had managed to possess nearly 500,000 documents, nearly all of which were somehow confiscated by the Ministry of Justice. And this is the catch. One day, she took me to the High Court. I think it's across the street of Yakatit Asrahulat Hospital. If you don't know it, if you haven't heard about it, what I saw was no less than tragic. Those documents were thrown out in the compound, but covered with gender in it. I was with her. Being a very courageous person, she walked, pulled out one document, and guess what? Rain had already spoiled a good number of those documents. Now, who is to be held accountable for such irresponsibility? We historians cannot reconstruct what you have assembled, what you have collected, almost selflessly. Without these documents. It's irksome, it's awful, it's absolutely irresponsible. Thank you, Mr. Chairman.
Thank you.
Excellent presentations and discussions. Briefly, I have one comment and one question. My first comment is I was very much taken by the comment that Dr. Edward Kisi made about antidote to future denial. I just wanted to make the interesting point that perhaps one of the most outstanding examples we have of a 20th century atrocity for which 70 years later there is now future denial. Power's gone off on the microphone.
Yeah, we can hear it.
We can hear you, man.
We can actually hear you, yeah.
Thank you.
Government is a transitional government, it's not an elected body. So can we really consider the Special Prosecutor's Office as a legitimate body that can really prosecute these people without it being a political prosecution? And two, Dr. Solomon, you've done your research in Gondar and Addis for over a year, over the past, and I'm wondering to know what you saw about the current living conditions of those survivors and victims, whether you were able to see some of the social and psychological impact that it had on them and how it still manifests in their way they're living.
Okay, thank you, Lucas.
However, I have the feeling that we are not emphasizing well on the root problem. The root problem is not simply Derg. Take Derg out of the picture. If ERP and Mason would have killed each other, and they practically did as the universities. A lot of the problem is using violence for advancing political agenda in general, even at political parties level. It's a sort of street politicking. So we should emphasize on discouraging that culture in general. Unfortunately, the Western human rights industries advance or encourage such kind of practice using different vague cliches like civil disobedience or whatever. And we are seeing the fruits in the Middle East. So I think we have to discourage, we have to emphasize on discouraging any kind of...
The first one goes with the decision to opt for prosecution rather than truth and reconciliation. I would like to know, after the closure of the prosecution, have you ever conducted a research to evaluate how the population have received, the Ethiopian have received the way the prosecution went, and both sides, the families of the perpetrators and the victims, how are they living together now? Is there no problem or any fear that this thing can happen again if there is no reconciliation process carried out after this prosecution? Then the second question, I would like to know whether there's any other mechanism set for, apart from the SPO, is there any other mechanism set to collect and disseminate testimonies? And also, if there is any mechanism for supporting the survivors in the process of resilience. And the last one is the experience of Rwanda shows that after such atrocities, the society faces a serious problem of trauma. How is it dealt if there is this case in Ethiopian case? Thank you.
Thank you.
Of the released their confessions. But one thing I'd like to raise is some of the points raised by Solomon. Professor Pedras said that I also believe that there are many generalizations that are being made. One thing I know for sure is that many of the victims, including their families, have not opened up, even now, because of several reasons. There is a culture of silence all around in the Ethiopian society. There are a lot of pains. We've suffered a lot, and many people don't want to speak about it. And some of them give it to God. I mean, let God take the action. So I'm sure
declaration of state of emergency, the justice is suspended in the process, or the justice system is suspended in the process. What are the mechanisms that ensure that at least basic human rights are not violated? I think you lawyers should elaborate on this issue for us, because groups during the revolution, be they PRP, Mason, etc., including the Derg, have justified whatever the actions they have taken in the name of the revolution, under the rules of the revolution, and have taken the law into their hands. And I think that's the crux of the problem. Thank you.
As a lawyer, your main objective there would be securing conviction of the accused, right? And to secure conviction of the accused, what you need to present is, let's say, the key documentary evidence and key witnesses. And they were in abundance. And I think even Yosef. So, if that is the case, calling victims' families to testify would add very little in terms of value, I mean in terms of importance for securing conviction, because the evidence is essential. So the reason why these people were invited to testify was not to secure the conviction. The reason related more to having this comprehensive historical record of the human rights abuses. And that's why I raised that question. Is prosecution, is the judicial system the appropriate forum, the appropriate mechanism to address this? Perhaps there is another alternative, whereby the trauma, the psychosocial impact, etc., of the victims, their families, the social crisis could have been studied. And maybe using lawyers was not the best option. Maybe we could have come up with a team of psychiatrists, sociologists, and other professionals, all right, who could have done this comprehensive record of testimonies. I mean, even the witnesses sometimes might not be willing to testify in court. I mean, the victims' families might not be willing to testify in court in public. Perhaps they don't tell more, they perhaps open up more if they were approached by a professional psychiatrist or a professional sociologist, you know. So, my whole point...
That documents mentioned someone names, for instance, Yosef. So, is Yosef is a person who was detained? Who is Yosef? First of all, we have to prove Yosef was one time born with some parents. He takes from his home by government officials or government soldiers to the prison. This is told by the family of the victim. No one can tell the court that Yosef was the guy. Yosef was the one who's detained by the Derg. So the family witness is very, very essential. It is important to support that document. Document cannot tell anyone. You read, Yosef was the PRT members, and the official of the government ordered Yosef to kill. Somebody reports that, Yosef, I execute the decision. This is the document. So, documentary evidence alone doesn't mean anything. We have to substantiate by witnesses. We use witnesses. For instance, the friend of the detainees. They told about that victim. He was tortured before he executed. So we present the family of the victims, not a document of Cabeza. Oh, you have this kind of document? She initiated to establish such type of document research center. As much as I can personally, as much as I can, I support her. Personally, I can say personally. Finally, sorry, it failed. Not totally failed. Maybe one day it will be with her. But her...
Wait.
I'll give you three.
Until then.
I'll give you a couple.
Okay.
To say so, in my view, is to really compare the bloody rivalry between the two.
The generation that followed, what it learned from them, or their action was a bad example to the generation that followed. So politics is represented as killing, or sort of a dead end. So many do not want to involve in generation because the generation, their predecessors didn't give them a good example. When I say good example, not objective. The generation that rose had a good objective, a noble one, but the way they followed was very wrong one. And that wrong path discouraged the generation that followed. That's my point. The Ethiopian people, yes, that's true. Had it not been for popular support, these organizations, EPRDA, PLF, wouldn't have come to power. Here I'd like to add something. People were tired of fighting. People believed that no more evil.
First, on the good point raised by Kumulacho about the dual mandate of the Special Prosecutor's Office, it seems to me he's right in saying that these mandates were intentional, clearly. I remember Ato Girma saying, the Chief Prosecutor, saying that they presented more witnesses than was necessary in certain cases, and this was in fulfillment of the second mandate, which was, I thought, Kumulacho's point. In any case, the more important point about the material, of which, for example, 100,000 was electronically recorded, and hundreds of thousands more that were not presented to the court, there is absolutely no excuse why this is not public. It is completely in violation of the proclamation that this has not been made public. And this is something that HRM and many other groups should advocate, that these are public property, they should go public. It's not normal, of course, for court records to...
I wanted to thank Gedru for raising the issue of the publication of the documents so passionately. And also I wanted to thank Professor Andreas for being so unequivocal in his support of this. Sorry. And thirdly, I'd like to thank Ato Yosef.
Human rights in Africa. And secondly, very sort of importantly for my role here now, I'm acting director of Justice Africa at the moment. It's a small NGO based in London. Some of you will know of it, many will not. And it's an NGO which has an office in South Sudan and sort of strong connections in the Horn of Africa, long-standing connections with groups such as Inter-Africa Group that is hosting this conference for us today. And I suppose the one thing to emphasize about that organisation is that it's always had this strong commitment to Pan-Africanism, and in fact was led by former director of the Pan-Africanist movement, Tajin Abdul Rahim, who was one of the founder members, together with Alex Duval. And Alex Duval, in fact, has always maintains an interest in the organisation and has been a strong proponent of this African Union Human Rights Memorial Project, together with Dawit Mesfin, who is the director of Justice Africa, but unfortunately both of them can't be with us today, so I speak really in their place, and with apologies from both of them that they can't be here. And really I just wanted to take this opportunity on behalf of the organisation to voice my great appreciation of all the contributions that we've had so far. And to thank, of course, to thank Tamrat and Megdas especially for all the work they've put into organising this conference, which I think, illustrates the potential really of this African Union Human Rights Memorial Project, both to promote the memory of atrocity on a continental level and also to reinforce what is already being done, by groups within Ethiopia in this case to to promote the memory of atrocities. So let me just tell you a little bit about Justice Africa's role in the project and in the network. But before I go any further, really my role here is to explain Justice Africa's participation and what we're hoping to get out of these, in particular this second day. We need to come back from this second day with a set of recommendations for a report that we will then feed to the AU, so it's very important and that I explain the background to that. But also let me introduce two other people who will be participating in this session, and I'm sure again you have already met them, but I think it's important just to give you a little bit of background. I have on my left Bonita Bennett, and Bonita is director of the District 6 Museum, and she previously worked as the museum's collections manager and research coordinator, so she's been involved with the museum now for over 10 years. And she is, has her background as a human rights activist and as an educator. So we're delighted that she was able to come and participate in this consultation and to share her experiences, her very valuable experiences of engagement with memorialisation in the South African context. Because part of the concerns of I suppose, the AUHRM in general and Justice Africa's involvement in particular is this kind of exchange, peer exchange and sharing of experiences between different groups within Africa. So thank you, Bonita, for coming, and Bonita will be speaking about her work shortly. And then I have on my right Solange Molusa, who is Deputy Director of Aegis Trust Rwanda, which has also got, Aegis Trust is an international NGO which also has offices in the UK and the US, and which runs the Kigali Genocide Memorial, which, if anybody's ever been to Rwanda, you will already almost undoubtedly have visited this memorial because it has such a prominent status and has been such an important contribution to the memorialisation of the genocide in Rwanda. And Solange's background is in local government, and she's been working at district level to support local communities as well. So, but I should really just also emphasise that both Solange and Benita have been involved in this loosely defined African Union Human Rights Memorial Network for some time now, and Solange in particular has been a great, supporter of the project, and again we're delighted to have you here. So let me just go back to Justice Africa and tell you a little bit more about what we're hoping to get out of this session and about the background. And some of you already know this, so I'm just covering all terrain. I will keep it brief, okay? So Justice Africa was awarded a grant, and we thank the Dutch government, to build a network in support of the African Union Human Rights Memorial and to hold a series of consultations in partnership with other groups in the emerging African Union Human Rights Memorial Network. And I suppose I should emphasise in the Ethiopian context there's the role of Inter-Africa Group, but also the role of the Ethiopian Red Terror Documentation and Research Centre, which is really sort of a founder member of this AUHRM. But really what I'm here to do today is to listen to what you've got to say and take note of it all. So just in terms of background, you can see here that we've had already 3 consultations at the African Union site that you've heard already